There are people out there that wonder, why is the Kohberger case taking so long to get to trial? In this episode, we're going to take a look at a legal expert on the West Coast about that.
That's good, because there's the public and the families. They all have issues about why this trial's not proceeding, and we need some answers from a criminal defense attorney.
You know, it is a death penalty case, the Kohberger case, and so these cases take a long time. It was set for trial earlier, but, the defendant waived his right to a speedy trial. Hi, I'm attorney Andrew Myers, and with me today is Southern California attorney Yoli Medina. Thank you for joining me, Yoli.
Hi, thanks for having me again.
So we're going to introduce a new participant this semester. I'm really lucky to have an intern with me, and her name is Intern Red. Thanks for being with us.
Thanks for having me.
Okay, so we're going to have you be the intern and kind of watch, and don't hesitate to participate if you'd like to. Yoli, I was browsing the news, as I'm wont to do, as you know, and I found this article. When could the Kohberger trial take place? Criminal defense attorney weighs in. So this was actually on a TV station, KHQ, in Spokane, Washington. And at that point, it had been 576 days since the crime in Moscow. And this TV station spoke to an attorney by the name of Kevin Curtis, a criminal defense attorney. So I gave Mr. Curtis, he works for a law firm that is based both in Spokane, Washington, which, as you know, is right across the border from Moscow, Idaho. But they also have an office in Coeur d'Alene, Washington. So I gave him a jingle, and lo and behold, he said, sure, I'll come on and talk to you. So we're going to talk to him in a minute, but I just thought that article was interesting, Yoli.
Yeah, is it Coeur d'Alene, Washington, or Coeur d'Alene, Idaho?
Oh, did I say Washington? I misspoke.
I think it said Washington.
Coeur d'Alene, Idaho. Coeur d'Alene, Idaho. Yeah, so they have the two offices, Spokane, Washington, and Coeur d'Alene, Idaho. And so, his firm works in both states. And I just thought it was interesting because so many people have, been critical that, the case is taking so long. And I thought it would be interesting to talk to him. You want to join in and talk to him with me?
Yeah.
Come with us, Intern Red. We're going to see if we can bring up Washington State criminal defense attorney Kevin Curtis. Okay, joining us on this episode is Kevin Curtis. Kevin is a criminal defense attorney, a member of the Washington State Criminal Defense Attorneys Association. Kevin, thanks for joining us.
Thank you for having me.
So I don't know where to start. It's such a complicated subject. A lot of people have complained that, not everyone, but a lot of people have complained that it's taking such a long time for the Brian Kohberger case to get to trial. And you've been outspoken about that. Can you explain to people why it's taking so long?
Yes, and I know that this happens often, both in homicide cases, but most particularly in death penalty cases. And the average time for a death penalty case from really date of arrest or charges to the time a trial begins is generally between 36 to 40 months, maybe a little bit more, sometimes a little bit less. But death penalty cases have much more motions, much more investigation than the average criminal case.
Are there unique factors in the Kohberger case that separate it from other? There's no case like it, but that separate it from other death penalty murder cases that would justify the time it's taking to do all the scheduling?
I think there are some unique factors in this case that have led us to a spot. We did have a trial date set back in October. The court, however, took that off the calendar and has ostensibly been dealing with other pretrial motions and hearings.
Well, let's take a look at some of the issues that the court had said they have to look at. And here they are. One of the issues that the court said was, here's a list, and this is a cut and paste from the court's own announcement that there was going to be a hearing. these are all the things that have to be scheduled. The motions to suppress, motions in limine, motions challenging the death penalty, expert disclosure deadlines, a trial setting. And that's only some of it. Are these all the issues that are taking so long, or is this just a simple matter of assigning dates?
Well, these are some of the issues, but not all of them, that lead to the length of time, particularly in a death penalty case. I don't need to go through them individually, but in this case, we've already seen from the pleadings that have been open to the public that we're going to be looking at substantial suppression motions regarding DNA evidence. We're going to be looking at substantial issues and expert testimony regarding cell phone, GPS tracking. Both sides, I'm sure, have had to retain experts on that, and there will be hearings as to the admissibility of their testimony first, what we call a Daubert hearing. And then, if admissible, there will be substantial expert testimony by both sides. The venue motion isn't even listed in here, or if it is, I apologize, but that's going to be a major issue. Where are you going to try this case? Are you going to try it in Moscow? Latah County, small community where the University of Idaho is located, where the crimes occurred, or are you going to be able to get a fair and impartial jury there? If not, where do you move it? The two other larger counties are both in the Boise area, quite a ways away from northern Idaho. And then there's Kootenai County, the largest county in northern Idaho, about an hour and a half from Moscow, has about 150,000 population compared to Ada County, which has only 40,000 population. So that goes into the preparation time. The venue motion has not yet been really aired in full. There have been questionnaires that have been sent out by the defense, criticized by the prosecutor, surprised court. But, so those questionnaires, actually what's going to have to happen eventually is that either the prosecutors and defense agree on one, or they air their disagreements and the judge approves a questionnaire. That goes out to whatever initial county the judge thinks they can try it in. If he thinks they can do it in Ada County, those will initially go out to 200-300 prospective jurors. And those answers, will then be returned, and based on either the responses in the questionnaires or the individual jury questioning that goes on in a death penalty case outside the presence of the other jurors, will then lead the judge to make a determination as to whether he thinks he can get a fair and impartial jury in that county, or whether he needs to go to another county.
Right. Hey, Yoli and Red, feel free to jump in, but let me just ask one quick question, and that is, in this day and age, I mean, of what use is a change in venue? I mean, back in the horse and buggy days, back when people stood on soapboxes and cried literally to the people in the town common, sure. But with, publicity like this trial has had, I mean, you're just across the border, granted, in Washington. We're here in New England. Yoli is down there in California. And I know there are YouTubers over the pond in England that are watching this case. What really good would a change of venue to just some other county in Idaho, would that really be an effective thing?
Well, that's a good question. But I think the answer still is yes. Perhaps not as much as in the past, as you referenced, with the advancements in technology, the instant reporting, social media. But again, remember, this county itself only has 40,000 people. Moscow is really a university town with about 10 to 12,000 students. Right. The majority, or not the majority, but many of the residents there are connected to the university. They're either employees, or they teach there. They're vendors. They provide services to the university. They're connected in some way. And this, occurred to, you have 4 University of Idaho students. You have many people that are related in some way or other to the victims, or the victim's family. So when you take the amount of population and then you look at the amount of people who can serve as jurors, i.e., are they old enough? Are they competent? Do they have felony convictions? Etc. You don't have that large of a pool of people that are intimately tied to this case. So the amount of publicity is one factor, but the connection in this case, to the university, to the victims' families, maybe to the police department, to even court employees. In a county that small, it is different than somebody who is watching it from a national or international media, but does not have any type of personal connection to the case or to the geography of the region.
Okay, I see what you're saying. To my point, that was just simply having to do with the publicity. That's only one factor. What a tiny county. And I guess what you're saying, and I didn't realize it was that small. I knew it was a small county, but if there's only that many people, what you're saying is that there's just not that many people that can serve. And of those, it's such a tiny pool. That would be one of the factors. And publicity is only one of the factors. Okay.
Yeah. And I have a
get it.
question. If let's say the court sets a trial date at the next hearing, and then the motion to change venue is heard and it's granted, let's say, and it goes to a different place, would that affect the trial date?
That generally would not affect the trial date unless there's going to be a facility issue with the county you're going to.
Okay.
Because the judge would be saying, listen, everybody clear your calendar for, let's say, 3 months, because we're going to start this trial on June 1, 2025.
Okay.
So, whether they start it there, he's advised both sides to have their witnesses and their case ready to try. And if the location changes, but the date doesn't change.
And one other question. Does the judge, when there's a change of venue, does the judge go along with the change? Is he going to be the same judge or is a different judge assigned?
No, it would be the same judge. What would happen is one of two possibilities. The most common is that, let's just take an example. Say they're going to move it to Boise, down in southern Idaho, the largest county, Ada County. Then the court would make arrangements with the district court in Boise and get a courtroom reserved for 3 months. And the court, the present judge and court staff would go down there, set up. The defense attorneys, prosecutors would get housing, bring witnesses in, so it all take place there. There is one other possibility, and it has been done on occasion, not as common, and that is you bring up jurors from those other counties, and you still conduct the trial in Latah County, but you conduct it with jurors from other counties who have less exposure or less connection to the case.
Interesting. I didn't think about that.
It's got to be. Oh, go ahead.
Well, I was just going to say it is, trying really to figure out which, both from an economic standpoint and from either, I guess, a publicity standpoint, because once again, it's going to be hard to shield jurors even from other counties from the amount of press and the local media, in addition to the national media in a town like that. I don't know if you saw some of the video clips or news media reporting even between the time the crime was committed and the time of arrest. But I mean, that town was just swamped with media from everywhere. You couldn't avoid it. Yeah. So that's going to have an impact, again, even on jurors if you brought them in from other counties.
Yeah. Is it a factor that I live in a relatively small town, and no matter what the town people do, taxes are always a concern. So is the economy of this a factor in not wanting to change venue? And people have their own theories about why the prosecutor doesn't personally want to change venue. That's been his town. That's been his turf for decades. So that's one theory why people think that they don't want to change the venue. But would the cost of this, simply taking the judge, taking the court staff that you mentioned, taking the witnesses, taking all these people to another county and going back and forth, or else hiring, paying for hotel rooms, is the cost of this whole thing, does that legitimately weigh in the factor as to whether or not to change the venue?
No, I don't think I don't think from the court standpoint it does. And from the court standpoint, they're looking at, can the defendant get a fair and impartial trial in this county? And obviously, anybody in any county is going to know about the case. Let's take a look at ex-President Trump's trial. I mean, in New York, you're not going to get people who haven't heard about the case, haven't
No.
heard extensive publicity, etc.
No.
But the question is, and it's going to be based on intensive questioning, is have they formed opinions? Have they really
Right.
followed it? How much do they know about it? And, do you believe them if they say they can be fair and impartial and separate that? So I don't think the cost is, I think the cost factor comes into account when you try to pencil out how much is it going to cost to move everything down to Boise versus how much is it going to cost to select a jury in Boise, bring them up here for 3 months and sequester them. So I just think if you've decided you're going to change venue, then you look at the two possible ways of doing it, and then you start penciling out economically what makes more sense.
Yeah, no, I get it. I get exactly what you're saying. I mean, and even if you could get somebody in Latah County that said that they'd never heard of the Kohberger case, would you believe them? And B, would you want someone like that? Or in New York, would you want somebody that never even heard the name Donald Trump, because he's just whether you like him or not, he's just been a big name. Would you want somebody that's been living in a cave and not heard of Kohberger out in that area?
Yeah, I mean, I just, not to make light in any sense, but I can just know what, a jury selection expert is probably going to tell you about the makeup of somebody who's isolated them so much from everyday news or news like this. And no, as a rule, from a prosecutor, you're certainly not going to want that person on a jury. From the defense, there's probably more attraction to somebody like that.
Yeah. Now, I want to ask you a question about some people, and notably Kaylee Gonzalez's father, have been very critical of it's taking so long. What do you? And I was listening to you when you said that this is, it takes years to get a case like this to trial. But what do you say to people like Mr. Gonzalez, who we've been in contact with and shared emails back and forth on this channel, who say, and I quote, "This case is turning into a hamster wheel of motions, hearings, and delayed decisions." I mean, I have a lot of compassion for the guy. I mean, he's been through so much, but how do you explain this to someone like him?
Yeah, it's very difficult, and you have to feel a tremendous amount of empathy for the victims, both from obviously the horrific loss and now this process in which they're unfamiliar with, and to the general public saying, listen, why would it take this long, after arrest, to simply have people present their evidence, have the defense cross-examine them, and get it to a jury? Why does it take so long?
Right,
And,
exactly.
I also want to point out, that judges, they have a full calendar. They have other cases, right? Like the Kohberger case is not the only case that this judge is working on. Is that right? I mean, they have a full load, right?
Yeah, I mean, that's a great point. So you have a county with, 40,000 people. It's a one-judge county, one district court, which is the court where felonies are tried. So I am sure that he had a full criminal and civil docket on his calendar before this case broke to begin with. So, you could have large personal injury, large criminal cases of other things. It's a college town, so you're going to have a lot of misdemeanor college incident situations. You have businesses, you have civil cases, you have divorces, you have juvenile, you have dependency. I mean, you have all sorts of litigation and things going through the courts. So he can't spend 12 hours a day on this case.
Wait a minute. This court, this is the second district court in Idaho. Are you telling me that they handle divorces and family matters and criminal and all of that? Because in my jurisdictions, we have separate courts that handle family and marital affairs and probate and all. This one court handles all of that?
Well, from a litigation standpoint, most of it will go. You will have a magistrate, which each state is set up differently, that can handle some matters. And if there is a consent, they can try some minor matters. But for the major criminal trials and civil litigation in particular, I mean, that gets handled by, judge. That's the judges in this case, ironically. But the point being that he had a full docket before this case broke. And now you're looking at a case that is going to have numerous pretrial hearings, venue motions, suppression motions, expert motions. You have the defense arguing they're not getting discovery. You're going to have discovery disputes. You're going to have the jury questionnaire issues, all of these different issues that arise that he has to find time for the hearing and the briefing in addition to the current docket. So that is one of the reasons, one of many, why this case can't or won't get tried within 12 to 18 months, nor would actually just a quote normal homicide, first or second degree murder case would probably normally take a year
Right.
to get to trial. And in this case, there's 2 phases to the trial. If convicted of the crimes as charged, or any one of the 4 crimes that qualify for the death penalty, if convicted of any one or all of those, then you have a whole second phase of the proceedings, which is the mitigation phase,
Right.
which can take another 2 to 4 weeks to be presenting evidence. But to get ready for that mitigation phase, you're required to do an extensive investigation, obtain records dating back from birth all the way through the person's history, medical records, school records. You're going to have to do interviews. You probably are, no question, you're having some psychological, mental health testing done. You're trying to find experts in the areas of audio, video, crime scene, blood spatter. I'm sure I am missing, the GPS, the cell tower technology, the DNA. So finding the experts who can do it, agreeing, retaining them, getting the material, having them fit that into their schedule. I mean, these processes, unfortunately, take that amount of time in a death penalty case, which is why this case is not out of sync from a time standpoint in terms of where it is at this point.
Right. I wanted to answer my last question a little bit by pointing out to, what happens when you rush a trial. And there you see when people rush in the upper right-hand corner. That's what happens when people rush. Here are some trials that have taken a long, long, long time from the time of the alleged crime to actually get to trial. Number 1, we have suitcase Sarah Boone, still untried 4 years after she allegedly killed her boyfriend by stuffing him in a suitcase. Of course, that's a unique case. She's been through now 8 lawyers. Lori Vallow out there in your area took 3 years and 2 months to get to trial. Chad Daybell, that took 3 years and 10 months to get to trial. The James Crumbly case in the Midwest, that took 2 years and 2 months. The Hannah Gutierrez Reed trial took 2 years and 4 months. Alec Baldwin is coming up, so I haven't done the math on that. I'm going to say that's about 2 years and 6 or 7 months. And finally, here on the East Coast, you're probably not as familiar with the Adam Montgomery case. A gentleman, I hate to use that word, who has been convicted of the murder of his 5-year-old daughter. That took 4 years and 2 months from the time the young daughter was deceased until that came to trial. So these cases, and I'm sure you could go through a litany of more, but that's just the ones that I found. That's how long these cases can take to get to trial. So it's really, the Kohberger case really isn't that outstanding, is it?
No, it isn't. And you look at a couple of those cases at least, and those weren't death penalty cases even. The Vallow case, they took the death penalty off the table.
Right.
And that was still, only 8 months different than, the not co-defendant, because they tried separately, but Daybell, who did get the death penalty. So it's not unusual. And your question was what happens. Number 1, the judge wants to be very cautious and careful in the rulings. They want to be as fair as possible to the defendant, give them all the protections they're entitled to in the Constitution, but they also want to be sensitive to both the prosecutor and the public and the family's desire to move this to trial as quickly, as possible, without risking the possibility of a reversal of conviction based on error. So you balance all of those if you're the court as best you can, but that's the time frame it takes to get through the number of motions. Add a couple more. You're going to challenge the constitutionality of the death penalty, regardless of whether it's been done numerous times in Idaho, which it has been done, because if the U.S. Supreme Court down the line does reverse it again, and you haven't raised it as an issue, you waived that right. So that's going to happen. And then outside of the normal course of the type of motions, investigation, experts, and discovery in a death penalty case, you can imagine what happens if the lead prosecutor, something happens to them, they retire, or there's, something happens to the judge or one of the key defense attorneys or the investigators. I mean, that can lead to, substantial delays from unexpected things as well.
Yeah, so I have a question. If the motion to change venue is granted, for instance, and the judge has to go camp out in another county, what happens to the cases that he's handling at the Latell County Court? I mean, isn't that going to put like a strain on the cases?
Sure. I mean, what the court will do is a couple of things. They'll try to work with neighboring counties to see if they can, transfer some of the cases to them. Particularly the criminal cases, or bring in a judge, temporarily a visiting judge or a rotating judge to handle the criminal docket, because without defense consent, you have to have those tried within speedy trial time periods. Civil cases, you can simply continue them if you have to, but they will do their best to bring somebody in to take some of so that some process is obviously going on during the judge's absence. But it's a strain on the system, and it's a financial strain on counties of this side. The amount of money that's going to be spent on this case is certainly, going to be well into the millions, and that's before you get to trial. And then if there are convictions and the death penalty is imposed, post-conviction appeals and hearings and proportionality reviews are again going to get into the millions on top of it, right, all of which the county bears the expense for.
Attorney Curtis, we have an intern this semester. We're lucky enough to have intern Red with us, and she's been sitting here quietly watching us. But before we were talking, intern Red, you had a question about people's mistrust in government and mistrust in wrongful conviction. Didn't you have a question along those lines?
I mean, I just don't think, I'm not going to state my opinion on the death penalty, but is it a huge rush to kill this guy if he's already off the streets? And what if maybe it just so happens that the government, because this would be a big surprise, that they were wrong,
Well, I have a question for you first. I just want to know how you got your nickname.
Hair.
Take a guess.
Yeah. So again, very good question, and this gets into the historical debate over the death penalty. Number one, there are people who don't believe in the death penalty and believe if there is life without the possibility of parole, truly they're never going to get out of prison. Just let them die naturally. Don't spend the money and the time to actually execute somebody. You have others that believe it's justified for the heinous crimes, and that it acts as a deterrent, and or that it's the proper measure of justice. But the danger of attempting to do this quickly and without utilizing our system, which is designed obviously to protect defendants' rights. It was said, I think it was John Adams, a couple of years ago, many hundred years ago, who said the system was designed that we would rather let 9 guilty people go free than convict 1 innocent person.
Right.
So that's how our safeguards are set up. So again, to get more into the 21st century, yes, we have now learned, through the Innocence Project, founded I think in the 90s, that we've had, I think, over 300 exonerations of people that have been on death row. I mean, and that's actual innocence. It's not, they didn't prove their guilt beyond a reasonable doubt. It's through DNA testing primarily, or some other methods that they have determined that these people did not commit the crimes they were sentenced to death for. And we also know that we have executed people who have posthumously been found innocent. So that is what the justice system here is trying to avoid. And that's why understanding it's so frustrating to the public, both the cost and so very frustrating to the families who suffered, such a unbelievable, unimaginable loss. But those are the balances, and that's why the process is designed to ensure that we don't get into that situation where we've had a rush to judgment. We have given the ultimate judgment, death, and we find out we were wrong.
That was a great question, intern Red. Do you have any other ones before we head out of here? That was a great question. Thank you. I wish I thought of that.
Honestly, have the families put any input on whether they want the Brian Kohberger to face the death penalty?
Yeah, I am sure. I mean, I don't have firsthand knowledge of this. I'm just speaking from my experience as a criminal defense attorney and handled several of these types of cases. Yes, the prosecutor has worked with them. They've been assigned a victim advocate, generally from the prosecutor's office, to relay what their feelings about the case are. I'm sure there were extensive discussions with them regarding what would happen if the state did seek the death penalty in terms of how long it would take, the delays, the frustrations, and getting the viewpoints of each of the families, and sometimes within the families themselves, there could be a difference of opinion. And those are all weighed very carefully by the prosecutor. They're not binding, of course, on the prosecutor, but they are considered very carefully. Likewise, defense at times contacts the victim's family and talks with them about their views on the death penalty. One of the earliest cases I handled that was a death penalty case here in Spokane County, my mentor, my boss, Richard Cease, about a week before the trial, went up and knocked on the door of the victim's parents and sat down and introduced himself and explained who he was, what he was trying to do, and asked if there's any questions he could answer. And by the time they left, they called up the prosecutor and said, we don't want to impose the death penalty. We want you to get off the table and have him plead to life without parole.
Wow, that's quite a story. That's quite a story.
Before we go, I know we're getting close, but I have a question. In the mitigation phase, is the mitigation expert or the defense allowed to raise any kind of mental disorders that the defense may have?
Yeah, absolutely. I mean,
the defendant may have, I should say. They do. Okay.
Yeah. Yes, that would be brought to the attention of the jury as what would be a mitigating factor for reasons to spare their life. So the jury would, not to get too technical on the proceedings, but the prosecutor presents aggravating factors as to why they believe the death penalty should be imposed. The defense basically presents their case as to what mitigating factors they believe are present.
And that's not a defense, right?
Pardon me?
It's not a part of the defense. It's a part of the mitigation.
It's part of the mitigation, because the jury will get one of two questions at the end. It says, either are there sufficient aggravating circumstances to justify imposition of the death penalty, or on the converse, are there sufficient mitigating circumstances that you do not believe the death penalty should be imposed? I mean, that's the ultimate jury verdict that comes back from them. So any type of mental issue would certainly be raised as one of the bases for them not to impose the death penalty. And as to that issue, you could, I don't see any signs of it yet in this case, but even if insanity isn't available to you as a defense in the criminal charge in the guilt phase, diminished capacity would always be available to you to reduce the crime of first-degree premeditated murder. And if you could put on a diminished capacity defense showing they didn't have the intent to premeditate or form the intent required, you might get a conviction for a different level of first-degree murder or second-degree murder, and that would mitigate the death penalty and take that off the table as well. So if you felt you had a strong enough case to negate an intent element, even on the guilt phase, you would put that in. You'd be required to advise the state of that, and then they would have access to the examinations and the mental records and the experts you relied upon to rebut that. If you don't think it's strong enough as a diminished capacity, you would then present it in the mitigation phase as a basis not to execute the defendant.
Wow, that's an interesting answer. Very interesting answer. I have I don't want to disparage anyone, but I have one crazy final answer question for you, and that is that in one of the previous hearings, I believe back in February of 2024, the prosecutor came out and said we need to try this case starting in June of 2024 because the high school is across the street and that's when the school buses will be clear. And I've been practicing law for several decades, as I know you have. Have you ever heard of that as the school bus is running as one of the factors in determining a trial date? Or am I off base to even ask that?
Well, not only have I never heard of that ever occurring before, I don't think we'll ever hear of it happening again. I mean, that's just very unusual, and I don't know the context. I didn't hear the statement.
Okay.
And perhaps it was meant or came out differently. You know, what I've said before is if they are going to do this trial in Latah County,
yeah,
either with a Latah County jury or a jury from somewhere else, if the proceedings are going to take place in Latah County, my best guess is that the judge would start it during the summer because he simply doesn't want the amount of publicity, the convergence of the national media, and this being on the paper every day while the University of Idaho is conducting their normal college semesters. That's probably one of the reasons the house was demolished, is because it stands as such a reminder daily to the students, the parents of the students at the University of Idaho, the faculty. You don't need that daily reminder when you're trying to educate kids and bring them up through the college. Now, that isn't as obviously as big a consideration if you're, sending it out to a different county. But if they're going to try it there, I would be very surprised if they said it. So perhaps, the school buses, maybe he was making a reference to the university. I would give him the benefit of the doubt that perhaps that's what he meant.
Well, all right. I didn't mean to open up this can of worms, but you had the can opener. How can many people question how you can have, not you, many people question how it could be that they destroyed the crime scene, they knocked down the house. Oh, sure, the university didn't want it there anymore as a reminder to the kids. But I mean, in my view, may elevate it as a very large, substantial issue. And a lot of people say, forget about this LiDAR and radar and all the rest of it, shouldn't the jury have an opportunity to do a view and go to the scene and just see how tiny that lot wasn't? And again, I apologize, but you opened the can of worms. Wasn't that a mistake as a trial attorney, to destroy the crime scene?
Well, I generally don't like to give my opinion as to rulings.
Okay.
What I try to do is explain the thought process as why it may have occurred or etc. Honestly, I am surprised that the prosecutor acquiesced in that.
I am too.
Surprised. I think for whatever reason, they must have believed that there was a strategic benefit to them in having it destroyed. And that may well be that from their inspections of the house, etc., they believed the defense could make much more hay. And this is just speculation on my part.
Right.
That when you're up in those rooms and going through the stairs and through the walls, that certain things wouldn't make sense to the jury, why you either couldn't hear or couldn't see, or a time frame.
Right.
It's better for them to be able to do it through a reconstruction, a 3D display. But if the jury went in there, they would think to themselves, I don't think this is, it could be done that way. So maybe they thought the destruction down the line, they can present it better, through the modeling that they're going to put on than actually a real life. So obviously they had some basis for believing it would not be harmful to their case.
Okay.
On the other hand, the defense, I'm sure, was just pleased to sponge.
Yeah, it's just you could argue that either way, but
I think that the house, if the house is there, for example, if I had a client and I was defending a client, I don't do criminal law, but if I was defending a client and my client claims he's never been in that house, I wouldn't care. I wouldn't want the jury to go there, to have the opportunity to go there and walk in there and have this vision of him walking up the stairs and have this vision of him there. It would be I wouldn't want that. Because
Right.
what I'm trying to do is reasonable doubt. And if the jury has reasonable doubt as to who could have heard what, they would want to go to the house.
Yeah,
Absolutely. Yeah.
I agree, and that's why, again, surmising. But there had to be, in my mind, at least a belief. We'll find out if it was correct or not. That there was some sort of strategic benefit or something that they thought that they are better off presenting it in a different fashion than the walkthrough, which, our normal reaction, I think the normal public reaction initially is, boy, as soon as a jury sets foot on that property, it's extremely damaging to the defense, and it's going to have a severe impact on the jury. But they made the decision. We'll maybe find out later why that decision, what the justification from the state for that decision was.
Attorney Curtis, thank you so much for your time, especially dealing with our technical issues that we had here. I thank you very, very much for giving us the time. We'll always remember that you were so giving of your time. If there's ever, I doubt it, but if there's anything we can do for you, let me know. So unless there's any final thoughts, Yoli, intern Red?
No, I just want to thank you for your time. You were very informative.
Yes.
All right. Well, thank you for having me. I appreciate it. And I'm unfortunate we meet under these circumstances, though.
Yes. Okay. Be well. Thank you. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions.